Good morning, everyone, and welcome to this Western Law Ethics webinar. My name is Erica Chamberlain. I'm the Dean of Western Law. I'm also a proud member of the class of 2001. And we're very excited to be celebrating Western Homecoming virtually with you this year, and to be offering this professional development opportunity given by Professor Randal Graham. Rand is an award-winning teacher who won the university's highest award for teaching excellence earlier this year, the Edward G. Pleva Award. He's also an award-winning novelist and just recently published the second book in his trilogy called Afterlife Crisis. Today he's giving a talk entitled Rude: Developments in the Judicial and Administrative Regulation of Lawyer Civility, which explores the limits of rudeness and bad taste, and how bad manners and incivility among lawyers are being handled by courts and regulators. Before we get started, I want to mention a few housekeeping items. We've built in about 20 minutes at the end of Professor Graham's talk, where you will have the opportunity to ask questions through the Q&A function, which is at the bottom of your screen. And my colleagues Holly and Michelle from Alumni Relations will serve as moderators for your questions at that time. So with that housekeeping out of the way, I'm going to turn it over now to Professor Randal Graham to get us started, and I will put the spotlight on him.
Thanks very much for that introduction, Erica, and thank you also for inviting me to participate in this year's homecoming. It's an honor to be the speaker this year and get a chance to chat with everybody about legal ethics, and it's an honor to have everybody choosing to spend part of their Saturday morning learning about legal ethics and the regulation of civility. So it's a great pleasure. I'd also like to, while I'm thanking people, thank Corey Meingarten for making this technologically possible and helping drag Luddite me through all of this to get it all set up, and also to Holly and Michelle for all of their efforts in bringing this to the people. So thank you very much for all of that. Thanks to all. And to the people attending, it's lovely to see all of you. I'm of course lying about that. I can't see any of you. Like the rest of you, all I can see is my face lecturing about legal ethics, but it's lovely to know that you're there. And I do really appreciate you taking the time out of your busy weekend to, oh, and I'm getting notes from people. Hello, Omar. Hello, Joel. Hello, everyone. And thank you so much for coming. And as Erica mentioned, the topic of today's lecture is civility. And civility is one of the weirdest areas of regulation that we have in legal ethics. It seems to regulate not so much what lawyers do. It's not a set of direct prohibitions that say, you know, thou shalt not violate confidentiality, thou shalt not meddle with client trust funds. Rather, it seems to regulate the sort of people we are. And, you know, you have to be the sort of person who is courteous. You have to be the sort of person who has good manners. And so I'd like to talk a little bit about this odd sort of regulation that we have at the law society level, and also how it's dealt with at the courts, and explore what the limits of that regulation might be, explore some of the difficulties inherent in regulating civility. So with that, let's get this underway. So I thought I had finished writing this presentation on September 28th. And I thought that I'd covered enough material on civility and professional regulation to fill about 40 minutes and cover off all of the Law Society's various requirements for an accredited presentation. And then September 29th happened. And believe it or not, that was an important day for civility, at least for me, because that was the date of the first televised debate between Trump and Biden. And as horrible as that particular night was for a lot of people, it was really interesting from the perspective of a person who's interested in civility regulation. Now, only one person on the debate stage was a lawyer. Only one person on that debate stage had been subject to civility regulation by courts and regulators. That person, of course, was Joe Biden. He told his debate opponent to shut up. He called his debate opponent a clown. He said various things that you're unlikely to encounter in a formal debate involving anyone who isn't Donald Trump. It's important for me to note at the outset that Joe had my sympathy. I'll state my bias up front. I'm strongly pro-Biden. I think Donald Trump is a terrible president. I note that he's become a ubiquitous symbol for what's being called the crisis in civility, something we'll be talking about in a few minutes. But what Joe's behavior did, for me at least, was highlight one of the major difficulties involved in policing and regulating civility. You see, I like Joe Biden. I liked his incivility, largely because it was deployed in service of a cause that I support, namely the election of Joe Biden to the presidency. Had Trump told Biden to shut up, I might have thought that was outrageous. And to me, that, recognizing that in myself, that's one of the difficulties involved in regulating civility. Sometimes we might regard instances of the same behavior as either justified or inappropriate, depending on the context in which that behavior takes place, the cause being supported by that behavior, or whether the person engaged in the alleged act of incivility is otherwise on our team or within our own ideological bubble. So how do we ensure that we're regulating civility appropriately? How do we ensure that we don't give a pass to incivility that we like in an unprincipled way while stomping out incivility that we don't like? How do we draw carefully tailored and clearly articulated boundaries around what is and what isn't permissible behavior? As we'll see from the two cases we're going to get to in a few minutes today, it's been difficult for regulators to strike that balance too. And I'm not blaming them at all for that. The appropriate regulation of civility really is one of the more difficult legal ethics challenges that face courts and regulators, particularly where the alleged incivility takes place in the context of a lawyer who's doing his or her best to serve client interests. So let me start with my own views about civility in general. I think civility as a concept is important. I wish everyone would be civil. I particularly wish everyone would be civil in the legal profession. I'm happier when everybody's civil. As a practical matter, I'm of the view that when civility is violated, when we see a display of incivility, that often telegraphs other underlying issues like general incompetence or a lack of preparation by the lawyer in question. And I say this fairly early in my presentation because there's a fair chance that that might be the last positive thing that I say about civility this morning. Because the focus of my remarks isn't going to be on civility itself, which is great, but rather about civility regulation, which is complicated. When you're talking about civility regulation, I think it's important to highlight one issue that is too frequently left by the wayside, and that is that civility regulation is, by definition, a limit on a constitutionally protected right. Not a right to be rude, of course, but a right to engage in free expression. We like to ignore the fact sometimes that people have a right to say a lot of things that I'd rather not hear, subject only to reasonable limits prescribed by law that can withstand charter scrutiny. But the default state is that all expression, without regard to its content, is protected under the Constitution, right? As lawyers, one of our duties is to protect that fundamental right rather than being too quick to look at ways to stomp it out. So given that, why do we see so much recent interest in civility? Well, most of the recent requests I've had to do talks like this one to speak on the issue of civility, they've been premised on what I mentioned earlier, what is called the crisis in civility that we're sometimes said to be experiencing in both Canada and the US. Incivility is said to be on the rise, right? We see this all the time in reference to politics, but we're also seeing a large rise in claims that there's a crisis in civility permeating the legal profession. Today's lawyers, it is argued, are markedly less civil than we've been in the past. And this amounts to some kind of crisis in the profession. I don't want to take that for granted, though. I'd like us to test that with something of a thought experiment. So civility, generally speaking, seems to relate to how we treat each other, our clients and the courts. Let's focus just on one of those contexts right now, the one that's most familiar to most of us. How do people in law firms treat each other? So reflect for a moment, thinking about civility, reflect for a moment on the way you're treated at work. Bearing that in mind, that picture you've driven up about how people treat you at work, cast your mind back about 50 or 60 years now and consider how you would have been treated in a law office back then. But when you're doing that, assume that 50 or 60 years ago, for the purposes of this thought experiment, you're a woman, or you're Black, or you're Jewish. If we want to suggest that there was a golden age of civility sometime before now, I think we have to assume that what we're talking about is the way that men of a certain race and social class tended to treat each other in their professional interactions. We certainly aren't talking about the way some of the same men treated women, members of visible minorities, religious minorities, etc. We're talking about the way they treated each other in sort of a cultural nicety kind of way, well faced with other people with the same background, the same socioeconomic class, etc. And the reason I point this out is that on a substantive level, through developments in the law and social developments more generally, it's arguable that we've generally improved the way we treat each other, right? The present era, oddly enough, might be the golden age of civility. Sexual harassment in the workplace, for example, in our profession at least, is now prohibited. We have a specific rule of professional conduct. It's Rule 6.3. More generally, discriminatory behavior is prohibited under Rule 6.3.1. Casual racism in the office, well, not by any stretch of the imagination has it been eradicated. It's less tolerated than it was in the recent past. We're inching slowly toward broader inclusion in the legal profession. As a society, we're doing a much better job than we used to do in regulating specific forms of what we might call incivility that used to be commonplace. So if we carve out all of the forms of incivility that have been targeted by clear, specific, substantive laws, hate speech, discriminatory language, sexual harassment, then what exactly are we talking about when we talk about incivility? Are we talking about manners? A lot of commentators think so. We'll get into that in a few minutes. And if we're really just discussing courtesy and manners, is this an issue that calls for regulatory attention with all of the attendant expenditures of law society resources, right? Resources that could be spent elsewhere, chasing down lawyers who've violated confidentiality, going after lawyers who engage in impermissible conflicts of interest, going after lawyers who meddle with their clients' trust funds. Every time we go after a Joe Groya, every time we go after a Bruce Clark, those are the two cases we're going to talk about today. Those are regulatory resources that could have been expended in pursuit of some other goal other than stomping out alleged instances of incivility. And I've gotten at least 3 messages in the last 10 seconds saying, or we could just reduce our fees altogether. So this is a concern that people have. So bearing all of that in mind, let's think about that while we discuss the cases and the regulations that we have before us. So what do the rules say? Before we dive into the specific rules of professional conduct that govern lawyers in civility, let's talk very, very briefly about the framework that brings these rules together. As all of you know, I'm sure, particularly those of you who've been forced to endure my legal ethics class, all of the rules and regulations regarding civility from the Law Society's perspective fall under the rubric of Section 33 of the Law Society Act, right? Section 33 is the section that prohibits professional misconduct and conduct unbecoming. We'll focus on professional misconduct. That's the general offense in the Law Society Act that is not defined anywhere. There's no definition in the Law Society Act, rather, of what professional conduct might be. But if you're charged with professional misconduct, the Law Society can bring a hearing under Section 34, opening you up to one of the punishments set out in Section 35. Now, professional misconduct, not defined in the Law Society Act, is defined in the regulations and bylaws established thereunder, including regulations and bylaws that are delegated to the Law Society itself to generate and enforce. And the Law Society has generated the rules of professional conduct, and they contain definitions, including a definition of professional misconduct. The most important one for our purposes is that anything that constitutes a violation of the rules of professional conduct, the general bylaw generated by the Law Society, any conduct that violates one of those specific rules counts as professional misconduct for the purposes of the Law Society Act. So if you violate one of the specific rules we're going to talk about today, that's punted up to become professional misconduct under the Law Society Act, opening you up to prosecution under Section 34 of the Act, and then penalties set out under Section 35. The penalties in Section 35, including for breaches of civility, extend all the way from a reprimand, just sort of being told not to do that again, all the way up to and including disbarment, right? So these are offenses that come with serious penalties. And something I've mentioned in class before, and I can't not mention it today. I have the embarrassing distinction of teaching the one course in law school that's actually a punishment under the Law Society Act. Section 35 includes the fact that you can be forced to take a course in legal ethics if you've violated professional misconduct rules. So for those of you who are here because you're forced to by the Law Society, I can only apologize. But it's important to bear that in mind. Any of the rules we're talking about today can lead rather to the imposition of a punishment up to and including disbarment. And indeed, we're going to look at a case where disbarment was on the table for a lawyer charged with civility-related violations. So that's the general framework. What are the specific rules we're looking at? We'll go very quickly through those rules so we can get to the cases. Generally speaking, there are a bunch of rules related to civility. The most important ones are found in rules 3, 5, and 7 of the rules of professional conduct. 3.2-1 deals with quality of service. A lawyer has a duty to provide courteous, thorough, and prompt service to clients. The quality of service required of a lawyer is service that is competent, timely, conscientious, diligent, efficient, and civil. And that, of course, describes all of us. Rule 5.1-5 is the rule of courtesy. A lawyer shall be courteous, civil, and act in good faith to the tribunal and with all persons with whom the lawyer has dealings. And then Rule 7.2-1, called courtesy and good faith. A lawyer shall be courteous, civil, and act in good faith with all persons with whom the lawyer has dealings in the course of their practice. Those of you who know me well know that at heart, I'm a stat interp nerd, and those rules do present a bit of a problem from a statutory interpretation perspective. Note in each case that the rules appear to differentiate on the one hand from the word courteous from the word civil. A lawyer has a duty to be both courteous and civil. We're supposed to presume that there are no extraneous words in legislation, that each of those words is there for a reason, they each mean something different. From the case law that we've seen, including the cases we're going to see in a minute, that does not actually seem to be the case. Based on the limited case law we have, it seems that when we're talking about lawyers being civil, we just mean courtesy. We are really just talking about politeness in both cases with both of those words. Indeed, in Alice Woolley's paper, Does Civility Matter? Now Justice Woolley traces through all the case law on civility and concludes that in every reported case that she could find, she did an exhaustive search. In every reported case she could find, the allegation of incivility arose from the lawyer's use of strong, profane, or rude language toward another person. It was just rooted in bad language or a lack of politeness. To make things slightly more complicated, it's important to recall that lawyer politeness isn't the same thing as ordinary politeness, right? As lawyers, we're often called upon to act in ways that might be considered rude outside the boundaries of our profession. Think about commentary 1 under Rule 5.1-1. That's the famous one, right? In adversarial proceedings, the lawyer has a duty to the client to raise fearlessly every issue, advance every argument, and ask every question, however distasteful, that the lawyer thinks will help the client's case, and to endeavor to obtain for the client the benefit of every remedy and defense authorized by law. So we're required to engage in behavior at times that would be regarded as distasteful in polite society. So how do these ethical duties measure up against our overarching duty of civility? If the duties come into conflict, should we have a hierarchy of duties such that one can trump the other? For present purposes, it's enough for us to note that the notion of civility isn't clearly defined in the rules, nor are there specific examples of behavior that count as uncivil without being caught up by one of the other more specific and substantive rules of professional conduct, like discrimination, like sexual harassment, things that we don't have to deal with under the civility rule anymore at all, because there are specific rules designed to deal with those things. So bearing all of that in mind, let's pause and look at some of the cases that we have out there for interpretive assistance. So in the interest of time, this is only a 40-minute presentation. I'm only gonna look at 2 cases. And those of you, I see that there are a lot of you who have taken my legal ethics course, a lot of my veterans from legal ethics and stat interp are here. At least one of these cases is going to be familiar to you. It's a 25-year-old case. We're going to talk about that. It's probably the high watermark for incivility. And the other case is only 2 years old. It's a 2-year-old case from the Supreme Court of Canada. And they'll both probably be familiar to a lot of you. But taken together, I think that they both do a good job of highlighting the difficulties involved in articulating the limits of permissible incivility. So let's get to the old favorite first. And this is one of my all-time favorite cases. It's the Law Society of Upper Canada, as it then was, versus Clark, right? The Bruce Clark case. And this is the 1995 Bruce Clark case, not the 1999 one. So what happened? Well, Bruce Clark was, and I emphasize the word was, a lawyer in Ontario up until 1999 when he was disbarred for a variety of actions that he took while representing the interests of Indigenous persons before the courts. Specifically, in 1999, the Law Society declared him to be ungovernable. Now, that's a pretty rare declaration. We don't often say that a lawyer is just too wild, too out there to be governed by the rules of professional conduct, and therefore they revoked his license to practice law. That was the second attempt to disbar Clark. The first attempt in 1995 is what I'm going to be discussing for the next few minutes. So Bruce Clark was a lawyer in Ontario who was devoted to the rights of Indigenous people, absolutely devoted to them. He made them his life. He had a PhD in Aboriginal studies, not a law PhD. He did have a number of law degrees, but he also had this PhD studying the rights of Indigenous persons, the history of Indigenous persons, and he held this legal opinion that grew out of his studies. That's an odd but ostensibly arguable position. In essence, what Clark believed was that a great deal of Indigenous people's territory was never properly surrendered to the Crown in accordance with procedures set out in the relevant treaties. As a result, he contends that these lands are still Aboriginal territory and that Indigenous persons living on them are not properly subject to Canadian law or to the jurisdiction of Canadian courts. This is where it gets a bit more complicated and contentious. He argued that the assertion of jurisdiction over Aboriginal people on those lands contributed to the current plight of Indigenous people and amounted to complicity in genocide, right? So any assertion of jurisdiction over those people that contributed to their plight, any assertion of jurisdiction over Indigenous persons on Indigenous lands that contributed to their current plight, their current dire circumstances, that amounted to complicity in genocide. Clark made that argument rather vocally. Right? In Canadian courts, he would shout a lot, and like serious shouting. I'm not talking about raising one's voice for dramatic effect, but actually yelling at people in the courtroom. My understanding is that at least once he even threw a book of authorities at a clerk and shouted something along the lines of "file this" while he shouted it. But he would yell, he would shout, he would make accusations. In affidavits that he filed, he accused the Attorney General of things. My favorite quote was accusing the Attorney General of cunning chicanery. And even complicity in genocide. He accused the Attorney General of that. He accused judges of complicity in genocide. During oral argument, he would regularly accuse the judge sitting before him of complicity in genocide. When his arguments made it all the way to the BC Court of Appeal, this will be familiar to students who took this course with this case with me years and years ago. He went all the way to the BC Court of Appeal. He continued engaging in the same sort of behavior and topped it off by attempting via citizen's arrest to arrest 4 judges of the BC Court of Appeal for complicity in genocide. It didn't end well. The judges didn't feel like being arrested that day, so didn't allow that to happen. But he actually tried to arrest judges of the Court of Appeal for the charge of genocide. So this gave rise, no surprises, to a number of complaints about Clark's behavior, ultimately resulting in a hearing before a disciplinary committee of the Law Society. And the hearing committee held, not a big shocker at the time, that Clark should be disbarred. That recommendation of the hearing committee was then carried forward to the benchers as a whole, sitting as convocation. And so the question that raised was, did Bruce Clark act with civility? Many years ago in my legal ethics class, probably 15, 16 years ago, I hauled out a bunch of benchers to the Law Society to come and have a debate about that in my ethics class. And so we had a judge present, we had the treasurer of the Law Society at the time, a couple of benchers, and they disagreed vehemently over whether or not Clark's behavior ought to have been regulated, ought to have been stamped out, whether he should have been disbarred. The question of Clark's civility was at the core of the discipline complaints against him, and my debaters just couldn't reach a consensus as to whether that civility was appropriate or inappropriate. And part of the difficulty, I think, lies in the political issues inherent in Clark's behavior, right? Remember, in all civility cases, what we're dealing with is prima facie protected expression. And Clark was dealing with undeniably important issues that are one of the most important issues facing the Canadian polity today. So here's what convocation had to say about those issues. I'll just read a few quotes from the judgment. It would be difficult to disagree with Mr. Clark's assertion that the issue that his argument raises is constitutionally critical. The discipline hearing panel found that Mr. Clark honestly believes that the comments and conduct particularized in the complaint, which are an outgrowth of his argument, were intended to advance the cause of justice and the rule of law. The genocide of which Mr. Clark speaks is real and has very nearly succeeded in destroying the Native Canadian community that flourished here when European settlers arrived. No one who has seen many of our modern First Nation communities can remain untouched by this reality. Had this activity been engendered in a context less fraught with significance and emotion, we would take a very different view of Mr. Clark's conduct. Well, the result of this was that the order for disbarment was overturned, right? Convocation said, given the context in which this arose, given the fact that more problems are caused by stamping out zealous advocacy, more problems are caused by lawyers being insufficiently zealous than by lawyers being too zealous, we're going to overturn most of the findings that Clark has violated any of the rules of professional conduct. They actually upheld one finding, and that was related to a technical assault committed upon a police officer. Clark had been attempting to engage in a trespass onto a specific piece of property. A police officer arrested him, and in doing so placed a hand on Clark's arm. Clark then said, unhand me, sir, and tried to move his arm. That was a technical assault that the Law Society upheld as being a violation of the rules of professional conduct. So they held that he had engaged in professional misconduct, but instead of disbarring him as the hearing committee had held, convocation sitting as a whole said that all he needed was a reprimand. My understanding of the way that reprimand went down is that Clark failed to appear before convocation when asked to appear before convocation. And so convocation left him a voicemail telling him that he was reprimanded. They were unable to actually reach the lawyer in question. So punishment for Clark for trying to arrest judges for complicity in genocide, for accusing attorneys general of complicity in genocide and cunning chicanery, for shouting things, for throwing things, for generally creating more than a hullabaloo in the courts, was a voicemail by the Law Society telling him not to do that again. So of course, that's 25 years ago. Let's bring all of this up to date and look at what the Supreme Court of Canada did just 2 years ago in the most recent leading case on civility, and that's the Joe Groya case. So Law Society versus Joe Groya, 2018, Supreme Court of Canada. Most of you probably know who Joe Groya is. Indeed, he's now one of the leaders of our profession in the province, having been elected a bencher of Ontario's Law Society. At the time that's relevant to this case, he was not yet a bencher. He was the lawyer for the accused in the Felderhoff matter. A lot of you will know the Felderhoff case. That was the one prosecution that grew out of the Bre-X mining scandal when they were salting cores of mines in Borneo, and there was a securities fraud associated with it. It was the biggest securities scandal in Canadian history, and Felderhoff was the one guy who ended up being accused in connection with the alleged fraud that took place in that case. And Joe Groya was his lawyer. The trial was more than a little unusual. One important note, though, before I get into what made the trial unusual, is to note that when all was said and done, Felderhoff was acquitted. In other words, Joe Groya won. What matters for our present purposes, though, is how Groya behaved while pursuing that victory. Throughout the trial, Groya repeatedly accused the prosecution, a lawyer named Mr. Naster, of prosecutorial misconduct. He essentially said that they were engaged in a witch hunt, and that they were just out to concoct a case to get someone who they could lay the blame for Canada's biggest securities disaster. Groya said that Mr. Naster wanted to convict at all costs rather than seeking the truth. He said that the OSC was disregarding the dignity of the proceedings. These are things he said out loud during the trial. He said Naster was disregarding the proper role of a prosecutor. He said that he was assessing all evidence and his own disclosure obligations through a convict at all costs filter. He suggested that the prosecution was essentially hiding evidence that might help the defense because they were hoping to lay an unfair trap for the accused, hide the whole story, and convict no matter the cost. These are fairly serious claims to make against a prosecutor. Any of you who are prosecutors will know that. It's essentially saying that the prosecution is behaving in a massively unethical manner, violating the rules of professional conduct, violating professional duties of a prosecutor, acting in an unjudicial manner, and acting in an unduly partisan manner that's not associated with the role of a prosecutor. It's not as bad as accusing a judge of genocide, but it's quite serious indeed. And to make matters worse, right, dialing back to Alice Woolley's article about the nature of language that tends to give rise to a claim of incivility, Groya allegedly used some fairly intemperate language when making these claims against Mr. Naster. When asked to substantiate any of the charges he was bringing against Naster, Groya essentially said that he wasn't yet ready to do so. He continued making those claims, nevertheless, about the prosecution, generally disrupting the unfolding judicial process. This led to a lot of acrimonious exchanges in the trial, as you might expect. Mr. Naster kept asking Groya to be put to the proof of his claims. The judge would ask Groya for proof. Groya would say, sorry, I'm not ready to bring any substantiation of the charges I'm bringing against the prosecution. And it made it a difficult fight for the prosecutor. And, you know, that's partly Groya's job. He wants to make things difficult for the prosecution. Anyway, what happened was the prosecution felt that the trial judge was losing control of the proceedings, and he asked to have the judge removed. This resulted in a judicial review of the trial proceedings all the way up to the Ontario Court of Appeal. This is where things get odd. During the judicial review proceedings, both the initial reviewing court and the Court of Appeal made a number of serious claims about Mr. Groya's conduct. The Court of Appeal opined that Groya's repeated attempts repeated claims rather of prosecutorial misconduct amounted to potential violations of the rules regarding civility. So when the Court of Appeal says this lawyer is behaving in an uncivil manner, the Law Society notices, right? The Law Society is likely to bring a charge. I have some quotes here of what the courts during this review process said about Groya's conduct. They called it unrestrained invective, excessive rhetoric, descending from legal argument to irony and sarcasm and petulant invective, theatrical excess, guerrilla theater, unrestrained repetition of sarcastic attacks, unsubstantiated attacks on the prosecutor's integrity. That's fairly placid language, but it's a very serious series of charges or claims to make, rather, about the nature of a lawyer's behavior at trial. Well, after the courts say something like that, as I said, the Law Society feels compelled to act. So Groya was charged with professional misconduct, and particularly for violating rules relating to civility, and his claim made it all the way up to the Supreme Court of Canada. At every level of the complaint process, all the way up to the Court of Appeal, every single panel agreed that Groya had violated the rules relating to civility. And the result was a suspension for 30 days. That's quite different from the result that we saw in Clark, right? Obviously, Clark accuses judges of genocide and gets a mean voicemail. Groya accuses a lawyer of prosecutorial misconduct and gets 30 days. Before we look at what the Supreme Court of Canada did with that, I'd like to pause for a moment to look at a quote from the Court of Appeal. Again, the punchline: the Court of Appeal held that Groya had violated the rules governing civility and had engaged, therefore, in professional misconduct in violation of Section 33 of the Law Society Act. What matters, though, is that they took the challenge of comparing Groya's conduct to Clark and saying, how do we have this outcome in the face of the outcome in Clark that we saw 25 years ago? Well, here's my favorite bit. I'll just read you the quote. "It's important to note that Clark was decided more than 20 years ago. Since Clark, the legal discourse on professional misconduct arising from incivility has evolved. In my view, the particular context of Clark makes it unsuitable as a benchmark for incivility. It does not reflect contemporary appreciation of the advocate's duty of professionalism." Right, so things have changed. Clark's behavior is no longer regarded as the high watermark of permissible incivility or civility that will get at most a slap on the wrist. We're going to assess things differently now. We look at lawyer professionalism through a different lens these days. So while Clark warranted only a slap on the wrist, the Court of Appeal upheld the 30-day suspension of Groya. Groya pushes this all the way up to the Supremes. So what happened at the Supreme Court of Canada? Somewhat interesting background, at least interesting if you're somewhat nerdy like me. Don't forget, this is a judicial review process. And the Supreme Court said very clearly that the proper standard of review in this instance is reasonableness. So they assessed the Law Society's decision, the 30-day, or the finding of guilt plus the 30-day suspension, through this lens of reasonableness. We will only overturn this if it's unreasonable. And having established that standard of review, they went on to accept entirely the Law Society's contextual framework for assessing whether a lawyer has committed an act of incivility. And they approached this through a three-stage test. Who doesn't love a three-stage test? They said you must assess the lawyer's behavior in three ways. One, what did the lawyer say? Two, the manner and frequency of the lawyer's behavior when he was saying what he said or when she was saying what she said. And third, the trial judge's reaction to the conduct. For example, did the judge find that the lawyer had committed contempt of court? Right? And we assess all of these three things to determine contextually whether this amounts to impermissible incivility. The Law Society proposed and applied that test. The Supreme Court of Canada agreed that that was the perfect approach to assessing lawyer incivility. So easy case, right? We just uphold what the Law Society said. No, the Law Society, or the Supreme Court of Canada rather, held that while the Law Society was correct in its methodology for assessing Groya's incivility, they applied that methodology incorrectly and unreasonably indeed when assessing Joe Groya's conduct. Recall rather that the first element of that contextual framework for incivility calls upon us to evaluate what the lawyer said. Well, what did Joe Groya say? Here, without getting into the specific language, he made repeated unsubstantiated claims of prosecutorial misconduct against Mr. Nestor. The Law Society had held that such claims amount to incivility where they are either A, made in bad faith, in other words, the lawyer doesn't actually think that the prosecution has engaged in misconduct, or B, they're made without any reasonable basis. So the lawyer does believe in good faith that the prosecutor has engaged in prosecutorial misconduct, but there's no real reasonable basis for that lawyer to have that belief. The Law Society and the court accepted, without much argument at all, that Groya had made his claims in good faith. So the Law Society had hung its finding on the hook that Groya had also made those claims without any reasonable basis. The Supreme Court of Canada disagreed here. Groya had made his allegations based on an apparent misapprehension of the laws governing disclosure obligations, a misapprehension of evidence law. The Law Society used that legal error as the basis for concluding that Groya's claim had no reasonable basis, right? You don't understand evidence law as it pertains to prosecutorial disclosure. Therefore, your belief was unreasonable. Therefore, you had no reasonable basis to claim prosecutorial misconduct. Well, the court essentially turned that finding on its head. Groya had a sincerely held incorrect belief about the law of prosecutorial misconduct. And the court said that that error gave Groya a reasonable basis for making his claim. The court said that allegations of prosecutorial misconduct will have a reasonable basis if there is a sufficient factual foundation for them, given the lawyer's sincere belief about the law of prosecutorial misconduct. So in essence, if you honestly and sincerely believe that it's prosecutorial misconduct to wear a red tie, then you have a good faith basis to make that claim. And if the prosecutor actually wears a red tie, you have a reasonable basis too. So repeatedly accusing the prosecutor of misconduct for wearing a red tie in that circumstance would be A-OK based on the Supreme Court of Canada's formulation. Well, based on that formulation, Joe Groya's good faith misunderstanding of the law of evidence essentially insulated him from any claim of incivility. Since what Groya said, right, this first stage of the three-stage test, wasn't enough to count as incivility, the majority felt that the Law Society's holding was unreasonable. The decision below was therefore overturned. In other words, Groya's conduct didn't count as incivility for the purposes of the rules of professional conduct. Important to bear in mind, I think also, while all of this is going on, well, the case is proceeding from the Law Society hearing in first instance all the way up to the Supreme Court of Canada. In the middle of that, Joe Groya is elected a bencher of the profession, right? And I don't know what we can take that to mean as a signal from the profession. I don't know if everyone who voted for Joe Groya, disclosure, I voted for Joe Groya and I knew about his conduct. I don't know what that says about the profession's views regarding Joe Groya's alleged acts of incivility. Maybe they were for him, maybe they were against him, maybe they didn't know much about Joe Groya's acts of incivility. But he'd been, on some level, given the imprimatur of the profession to be one of our leaders at the Law Society level. Where does all of this leave us? It leaves me with a sense that it's really hard to punish a lawyer for incivility, at least where the alleged incivility takes place in court and we don't have a clear finding of contempt. There's a continuing reluctance, first seen in the Clark case, to draw a clear line regarding the impermissibility of uncivil conduct. And from my perspective, that's probably a good thing, right? That reluctance should exist. Why? Well, because it's really hard to make an objective assessment of when alleged incivility is appropriate or justified. As I said at the outset of this talk, when talking about Joe Biden versus Donald Trump, it's really easy to find that someone's rudeness is unjustified when they're on the opposing team. When someone's supporting a cause that you find just or a person you consider to be righteous, it's a lot easier to forgive them for behavior that in another person, in another context, you might regard as uncivil. Right? Clark was apparently undertaking a good faith effort to support Indigenous rights. Groya was apparently undertaking a good faith effort to defend a client who was faced with really serious sanctions, facing charges for the largest securities debacle, the largest securities fraud in OSC history. Would it have been better off, would anyone have been better off if Groya had been more polite in doing so? Well, Mr. Nasser would have had a better time. Would Groya still have been successful in vindicating his client's rights? Would a person who is ultimately found not guilty have been found not guilty had Groya not engaged in guerrilla theater? I have no idea. Is a touch of incivility a valid strategy sometimes? If so, how far can it go? Is it valid only so long as it doesn't cross a particular imaginary line that it's hard for us to draw? I don't know. These are incredibly difficult questions. They're really tough lines for regulators to draw. They're tough lines for reviewing courts to assess. In the end, despite what the Court of Appeal tried to do in Groya, it seems to me that things haven't actually changed much in 25 years. The benchmark for incivility is still incredibly elusive. The proper approach to regulation or deregulation is something that we're still struggling to try to attain. Well, this leaves us with two pieces of good news, though. Piece one, the first piece of good news, is that we're a self-governing profession, right? To the extent that you out there in the interwebs have strong feelings about any of this, you have a direct voice in establishing, varying, or eliminating standards with respect to the regulation of civility. And maybe we'll explore some of that in the question and answer period. And the second more important piece of good news for you is that this brings me to the end of my presentation. All that remains is for me to thank you for your time and to wish you a very happy homecoming and to take any questions that you might have. Thank you very much.
Thanks very much, Professor Graham. As always, you've managed to pack a lot of really important content into a fun and engaging presentation. I really enjoyed it, and I'm sure the rest of our alumni out there enjoyed it as well. We've got some time now for Q&A. So you can enter your questions in the little Q&A box at the bottom of your screen, and my colleagues Holly and Michelle are going to moderate this part of the discussion. I notice we've got a lot of questions coming in already, and hope we'll get to some of them. Probably won't get to all of them, but I'm looking forward to this part of the discussion. So I'll turn it over to Holly and Michelle now.
Hi there, good morning. There are a number of questions that have come in, and let's kickstart it with Omar. Omar has noted, in practice, we still see enormous amount of incivility on files. In pushing the issue, every lawyer involved shrugs and says they have an honest but mistaken belief. In other words, the Groya case has provided a license to counsel to act in any way they please. The regulator has been defanged. Omar asks, are cost consequences then the only way to address misconduct by lawyers? Is that the best place to assess this behavior?
From the court's perspective, I mean, if it's incivility, I understand Omar to be talking, by the way, love Omar, hello. If Omar's dealing with incivility that takes place outside of court, then that's one thing. Incivility in court, of course, we have the backstop of contempt of court, the one common law crime that remains. So we do have some mechanisms for in-court incivility, but I understand Omar's question to be talking about civility that takes place outside of the judicial context, like not in court, but lawyers acting against each other, lawyers engaged in various acts of incivility when they're not in front of an arbitrator, a judge who can actually enforce some rules of civility using the contempt power. That's an incredibly difficult question. Costs massively important, as Omar points out. Historically, and I'm not saying we should take too much from history, because again, our history of incivility is very, very different from what we're facing right now. Historically, it was reputational cost, right? That was the thing that was more likely to rein in a lawyer's behavior. So if I'm a complete jerk to Omar on one file, then the next time I'm going to face Omar, the likelihood is that Omar's not going to grant any adjournments that I need. He's not going to grant any indulgences that I need. He's not going to bend even a little bit in instances where he might have bent had I not been such an ass when dealing with him on prior cases. So reputational costs used to be massively important in terms of reining in incivility among lawyers. Is that the case anymore? It's a lot harder for that to be the case when the likelihood of repeated interaction is low because the volume of lawyers is high, right? So when you're dealing in an area like Toronto, where you've got a bazillion lawyers, you may or may, and you have large subsets of the bar for each practice area, there's some likelihood that you might not be facing the same person again. So the ability for you to mete out reputational costs on that person are going to be low. So it seems like Omar's prediction might be correct. The only practical way to deal with these sorts of issues is through an order related to costs. Now, I will lay my own bias out on the table. I have some sympathy for Alice Woolley's view. When she was Professor Woolley, as she then was, she was one of our leading ethics professors in Canada. And she and I used to write together sometimes and engage in some banter about civility. And I largely endorsed her view that there are more important things for the Law Society to be dealing with, in large part because of the costs associated with civility regulation, the difficulty of drawing the line, the probability of ideological appropriation when it comes to interpreting what those boundaries of civility might be. But I do get fussed when incivility relates to a power imbalance, right? When we have a lawyer somewhere higher up in the social, legal, whatever hierarchy, being a complete jerk to someone who has a relative lack of power. That's when I get particularly bothered. Otherwise, do I think that we need to have other mechanisms to rein that lawyer in now that the Law Society's been defanged? I'm not sure. I'm waiting to see what future cases hold, but I do wholeheartedly agree with Omar that following the Supreme's decision in Groya, there's not much for the Law Society to do, at least when it comes to legal claims being made by lawyers, right? If I'm in trial with Omar and Omar just starts calling me names, then that's one thing. If Omar starts making legal claims and then claims to have a good faith basis, unless there's some evidence that there's no good faith basis, right? If we have prior cases where Omar has developed or has demonstrated an understanding of the relevant area of law that is incompatible with what he's now asserting as good faith basis, that's going to be different. And we have to remember that in Groya, the Law Society from the outset just admitted a good faith basis. They didn't try to challenge that. So maybe that's the new area to fight, challenging the lawyer's good faith basis. But long answer to a short, tight, focused question. I agree, there's not much we can do other than a costs award, but we can think about things like reputational cost and challenging good faith understanding. Thanks for the question, Omar.
Okay, great. And the next question is from James. Professor Graham, do you believe that in the presidential debate, if Biden had spoken to the moderator rather than his adversary, he could have maintained civility and effectively handled his bombastic opponent?
That's a great question. It is way above my pay grade. I don't know that anyone could have maintained professional demeanor when faced with Donald Trump. I mean, if you just saw the Trump town hall, and the other day, I haven't seen anyone so far who's been able to rein that fellow in. So would speaking to the moderator have been a better idea? Maybe from a civility perspective, maybe not from the view of the electorate. Remember, Biden's most important audience was not a court or a regulator or a bunch of lawyers interested in how we deal with civility. Biden was looking for a different gain through his acts of ostensible incivility. And that was striking a particular note with the electorate. That's an important thing to think about, I think. We used to, when Clark was a shinier and newer case, we used to argue a lot about whether or not his behavior was justified. And what do you get out of acting in an ostensibly uncivil manner? Well, Biden gets attention of the electorate. Biden, the memes going around about Biden telling Trump to shut up the next day were largely pro-Biden memes. People, it seems to have resonated with people. Finally, someone told this clown to shut up. And with Clark, the argument I've seen trotted a number of times was the main thing that his Indigenous clients needed at the time was publicity. The main thing they needed was people to become aware of the plight of Aboriginal persons. Remember, we're dealing here with cases in the 1990s when this wasn't, there was a lack of public awareness compared to what there is now regarding the plight of Aboriginal people or the plight of Indigenous persons. Clark jumping up and down and throwing things brought some attention, right? So maybe incivility in support of a cause that you regard as just, or incivility that's going to give rise to a benefit that you think is worth the cost of a charge by your regulator, that you think is worth the cost of having to fight your regulator in court or before a hearing tribunal, maybe that's worthwhile. Thanks for the question, James.
Lauren asks, what is the comparison between US and Canadian civility rules governing lawyers?
That's a great question. I don't have a specific answer before me right now. I don't specialize in American rules regarding civility. One thing to note, though, is that the American regulation of lawyers is much more carefully governed by the courts rather than bar associations like ours, right? Like primary governance over lawyers in the US bar is by the courts. It's in the hands of the courts rather than being in the hands of regulators like our law societies. So the case law is very different. The legal framework is very different. What is expected of lawyers is very different. I think in the US, you're much more likely to see exercises of the contempt power. I once had an American judge up for a visit who sat in on some of my classes and listened to me talking about the way we regulate lawyers in Canada. And he basically his mind exploded because it was so different. So it's an incredibly different framework. It's a totally different sea. So I wouldn't hazard the risk of trying to opine too thoroughly on the nature of lawyer regulation. The ABA model code is not radically different from our FLSC model code. The rules that they lay out are not radically different from ours. There are some important differences. And when we drill down to specific sorts of claims that lawyers might make, one area that I've looked into American law a little bit more than others is bluffing, right? When you're engaged in negotiation, to what degree are you allowed to bluff in different jurisdictions? When does that count as incivility or inappropriate behavior? When does that count as dishonesty? And the rules are very, very different from jurisdiction to jurisdiction. In the US, if you make a claim in negotiations, for example, that we might regard as dishonest in Canada. If you say, you know, my client's walkaway figure is $5 million from this negotiation, when really you know in your head that the walkaway figure is $10 million, right? And you're lying about it. Well, the ABA rules specifically say that items like the price of the item under negotiation is not a material representation for the purposes of lawyer negotiations. Well, there's nothing more material than the price of the item under negotiations. So deeming that to be immaterial is just a way to allow lawyers to lie to each other, to bluff with each other during negotiation. In Ontario, we also take a very standoffish way of regulating lawyer dishonesty during negotiations, bluffing during negotiations. In Alberta, by contrast, they take a very hardcore stance, such that for many years it has been the case that if you're a lawyer in Ontario negotiating against a lawyer in Alberta, you're allowed to bluff the lawyer from Alberta, and the lawyer from Alberta is not allowed to bluff you back. So, you know, that's silly and unsustainable. So you're very astute to ask the question, you know, how do different jurisdictions deal with this? The question is radically differently, how lawyer expression is treated from one case to the next, whether that involves incivility, whether that involves dishonesty. But I'm no expert on American rules related to civility. Thank you for the question, Lauren. Nice to see you, by the way.
Great. James, next question. What role do you think the judiciary's level of blameworthiness is for the decline of civility in the course of litigation?
That's a great question. I haven't really thought about it. Do I think the judiciary, do I perceive a decline in civility? I don't even know. Like that premise of the question is the thing that I challenged at the outset, right? I don't have enough familiarity with old-timey trials and modern trials to compare them and see how lawyers treat each other. I don't know that lawyers were actually more civil to each other. And if they were, there are these race and class and sex issues that arise now that didn't arise then, and that lawyers were, you know, much more horrible to each other when they were dealing with a person of a different race, a different gender, et cetera, et cetera, et cetera. So I don't necessarily accept the premise of the question. I don't know that there has been a decline in civility. If there is, how much would I blame the courts? Probably not much. I mean, is it okay for the courts to give a loose leash to the lawyers in front of them? Given the comments of the Law Society and Clark, right, that much more harm has been done to the cause of access to justice, to the administration of justice, and to the reputation of the administration of justice by being too eager to stamp out zealous advocacy, right? More harm has been done by that than by lawyers being too zealous. If we accept that calculus, and you know that's an empirical claim open to discussion, open to some evidence disproving it. But if that intuition by the Law Society is correct, then giving lawyers a bit of free rein probably hasn't contributed overall to too much harm, right? Maybe we have greater access to justice. Maybe we should have people screaming and shouting from the rafters in the cause of Indigenous rights, for example. Maybe we need more people shouting about more injustice. Maybe if our arguments aren't being heard, the thing to remember about Bruce Clark, he was trying to make his argument about the failure to properly assert jurisdiction or the improper assertion of jurisdiction over Indigenous persons. Courts repeatedly told him, stop making that argument, right? You're not allowed to make that argument in my court. I've heard your argument, sit down and be quiet. That was said repeatedly against Bruce Clark in those cases, and Bruce Clark refused to sit down and be quiet. Well, do we want a world in which that's the stance courts take, right? I'm sick of your substantive argument that you're making. The Law Society actually said he hadn't been allowed to fully develop his argument in any court. That's a Law Society claim. I assume it's true. I don't know how that looked at the time. I wasn't actually ever in any of those trials with Bruce Clark. But if we take that as a given, that the Law Society is accurate in saying, that Convocation is accurate in saying that Bruce Clark had never been allowed to develop that argument, well, that's going way too far. So if the balance is, should courts be allowed to go further in suppressing statements that their lawyers are making, or should the courts give lawyers free rein? It seems that giving lawyers a looser leash is probably the right balance, is probably the right calculus. But again, the whole point of this presentation, as you've seen, is that it's an incredibly hard line to draw, and I'm glad I'm not the one who has to draw it. I just get to, you know, take pot shots and problematize things. but it's really difficult. And I certainly, tip my hat to regulators and courts trying to regulate this. Do they do it always the way that I would do it? No. Do I recognize that it's incredibly hard? Absolutely.
Anita asks, is there consistency respecting regulation of civility across Canada, mindful of mobility rights?
Civility itself, largely. Over the last few years, as you've seen, thank you for the question, by the way, I appreciate the question. Things have changed quite a lot in terms of the rules of professional conduct across Canada over the last 8 or 9 years. And that is all due to the rise of the Federation of Law Societies of Canada, right? It used to be the case, and it still is legally the case, that every province has its own regulator. We all have our own law society, and those law societies are each individually responsible for promulgating their own rules of professional conduct. And those rules of professional conduct in the past looked radically different from one another, right? We would have quite different rules, quite different rule numbering, quite largely the same concepts. Like everybody dealt with confidentiality, everybody dealt with conflicts of interest, everybody dealt with civility, et cetera, et cetera, et cetera. But the way they dealt with them was often quite different. That was seen as a problem, largely because of the concern that you specifically raise, and that is lawyer mobility, right? A lot of lawyers are called in multiple provinces. A lot of lawyers want to move around. Maybe one day we'll live in a world where we're allowed to cross provincial borders again, and this will become a pressing issue once again. Well, the Federation of Law Societies is an effort by all of the law societies in Canada to come together and create some level of uniformity. So the Federation came together and they generated this model code of professional conduct that changed all of the rules of professional conduct to some degree in order to create, like the ABA code, a model code that had the goal of uniformity across the country, rather. Of course, the Federation of Law Societies has no legal authority to impose its model code of professional conduct from province to province. Instead, they simply have a meeting of all the law societies who come together. They each send delegates to the Federation. They generate the code together. They then bring it back to their individual law societies, who are then encouraged to adopt it. And each law society has adopted it with a few modifications here and there. Ontario has among the fewest modifications. Why is that? Is it because Ontario is particularly rule compliant and we like to do what we're told? No, it's because the Federation's first iteration of the model code was based on the Ontario rules. So what were just Ontario specific rules, we're taken as sort of among the gold standard rules that could be looked at by the Federation of Law Societies. The Federation then looked at that, promulgated this model code, and then provinces have more or less adopted the rules of that model code across the country. So we are seeing far greater uniformity in the present epoch than we were even 10 years ago. So yeah, civility regulation in terms of the content of the rules is pretty similar across the country. How they're going to be interpreted, how they're going to be applied, that's going to depend on your individual law society hearing panels. But we have this signal from the Supreme Court of Canada how in-court incivility is going to be treated, and that, of course, is going to govern how that's treated across every jurisdiction in Canada. Thanks for the question.
Thanks, Rand. Lauren asks, how important is the role of culture in the interpretation of incivility? By measuring against Western rules of engagement, are we engaging in implicit bias toward internationally trained lawyers?
Oh, well, happily, this is a question that I can answer in 30 seconds. No, it isn't. This is a huge can of worms, which I know you know that, Lauren. Thank you for the question. And this touches my simple heart with respect to issues of statutory interpretation. Those of you who know me well know that my main gig is as a statutory interpretation professor. And I believe that we cannot help but interpret a text through the lens of our own biases. My own writing on the judicial interpretation of legislation, on the administrative interpretation of legislation, all hinges on the fact that we cannot help but interpret language through the lens of our own biases. And I look at very simple cases where we're, farm animal legislation governing the use of animals, and we see people saying, oh, well, these are all animals that are used as food. And of course, that comes with massive cultural bias when you're deciding what animals qualify as food animals, what animals don't qualify as food animals. Well, if we're doing interpretations like that are ideologically informed, that are culturally informed, in something as simple as farm regulation, imagine when it comes to the regulation of professional norms. So absolutely, that is hugely important to exercise a large amount of cultural awareness, a large amount of understanding your own privilege, a large amount of understanding what cultural values should not be allowed to infuse our rules of professional conduct through what looks like ostensibly objective interpretation. That's a massive issue. This is something that I've spent most of my career fighting about. So alas, it's not a question I can answer in 30 seconds, but I would love to have a coffee with you and chat about this at length because it's something that I care about deeply. So thank you very much for raising that.
Thanks, Professor Graham. And I'm afraid we have reached our hour. And although there's still plenty of questions, we need to wrap up for today. Obviously, this is a topic on which there is a lot of interest. And so we really are thankful for your engaging presentation. And thanks to everyone who joined us today. Thanks for taking the time to connect with Western Law. And I will confirm that this presentation is accredited for 1 hour of professionalism hours through the Law Society of Ontario for those of you who are looking for CPD hours. So thanks. Can we please thank Professor Graham virtually as we can for his presentation today. And for everyone else who's joined us on this Saturday morning, I hope you enjoy the rest of your day and that you have a happy homecoming.
Bye, everyone.